Whether the spouse seeking the divorce from a service member or the service member themselves, there are many issues surrounding the initiation of a divorce proceeding when a service member is deployed. If you are the spouse seeking a divorce from a service member that is deployed, your first step is to actually locate the service member on duty in order to serve him or her with the summons and your complaint for divorce. In order to locate a service member on deployment, the most important piece of data there is the Social Security number. If you do not know the service member's Social Security number, you can find this on any joint tax return, on the service member's LES or leave and earnings statement, or on a copy of the service member's orders, whether past or present, and on other military documents. You can then check with your local armed forces recruiter, especially if the service member entered military service in your locality within the last year or so. Another approach is to contact the base locator at the last installation at which the service member was stationed. You can also seek the assistance of a military legal attorney who is authorized to assist service member spouses for legitimate legal purposes, such as service of process of a divorce complaint. Your next step is to actually serve the service member with the complaint for divorce, which can be done through service by mail or service on base by a deputy sheriff or a process server. If the service member is deployed abroad, service of the divorce complaint can be more difficult and can take additional time, as country-specific rules must also be considered. If you are the service member from whom your spouse is seeking divorce, there are protections in place for those in the armed forces set forth in the Service Member Civil Relief Act. Courts generally construe this act liberally. The purpose is to protect and enable the military to devote their energy to the defense needs of the nation and to provide for the temporary suspension of judicial and administrative proceedings that might adversely affect the civil rights of a service member during his or her military service. In particular, when service members are involved in a lawsuit, the court and Congress, when enacting the Service Member Civil Relief Act, recognize that it might be difficult for the service member to participate in the proceedings while they're involved in the defense of the nation, and that their job can make it even harder to turn their full attention to the prosecution or defense of legal proceedings, including divorce. The primary remedy under this act is for halting the lawsuit with what's called a stay of proceedings. These stay orders are uniquely useful in domestic relations litigation, such as divorce, and provides a means for suspending the divorce action until the service member who is a party is available to participate. This results in a fairer exploration of the issues and a fairer trial. My name is Ruby Painter, and I'm an attorney here at New Beginnings Family Law.
New life, new direction, new beginnings.